Hello students, so we will be discussing the next set of 25 questions. So going to question number 26. When an application claiming from relief from oppression or mismanagement is made to the tribunal may. So this question is also related to powers of tribunal under section 242. So imposition of cost as it may deem fit, make an interim order, make an order altering the memorandum. So all these powers can be exercised under section 242, that you are about that. Okay. Then moving to 27, after considering the report of inspection, the central government is empowered to make an order prohibiting the banking company from receiving fresh deposits. So this is related to Banking Regulation Act 1949. So when you are hearing the term inspection, you might think that it is coming from the chapter inspection, inquiry or investigation, but it is related to banking company. Directing the Reserve Bank to apply for winding up of company, either A or B. Okay, so the answer is 3. That means option C is the correct answer. So government will be empowered to prohibit the banking company from receiving fresh deposit, and it can direct Reserve Bank to make or pass order for winding up of banking company. Company which has incurred losses in dash shall not be granted certificate of registration. Section 3 of Sarfasi Act, not incurred losses in preceding 3 financial years. Okay, any of preceding 3 financial years. Good. The concept of rotation of auditors is applicable to all companies. So that rotation is applicable to listed company, public company having paid up 10 CR or above, private having paid up 50 CR or above, or companies having borrowing from financial institution, bank or public deposits of rupees 50 CR or above. So option is C. Any merger by reason of which the enterprise remaining after merger has in India or outside India, not of, that is typing error, or outside India, in aggregate the assets of value of more than. So this is related to combination. Okay, so enterprise which is merging have assets in India and outside India. Okay, so the threshold for individual will be 1 billion US dollar, and assets would be, turnover would be 3 billion US dollars. So the option will be 1 billion US dollars, 3 billion US dollars. Then minimum component in India 1000 CR and 3000 CR respectively. So the option would be C. A company shall not declare any dividend on dash if it has failed to comply with the provision of 73-74. So that is equity shares. Okay, so that is clear. Then in case of an insurer carrying on the business of life insurance or general insurance, minimum paid up equity capital shall be 100 CR, section 6 of Insurance Act 1938. The central government may enter into an agreement with the government of any country outside India for enforcing the provisions of this act, exchange of information for prevention of offence relating to money laundering, promoting friendly relation. Promoting friendly relationship is not correct, so the answer would be C. So this is Prevention of Money Laundering Act. In the board meeting of Devil Limited, 9 directors are present out of 12. Okay, so total 12 directors, then 9 directors are present. 9 directors are present. Suppose 3 directors voted against the resolution and 1 director abstained from voting. So 1 director has abstained from voting and 3 directors have voted against. Okay, so number of valid vote will be 8. That is 9 directors are present, valid vote would be 8. So if 3 directors have voted against and if 4 directors are in favor of that, resolution would be, board resolution would be passed. So the answer would be 4. Okay. Then eligible members may make an application to tribunal seeking an order of investigation. Section 213 of Companies Act. On receipt of such application, tribunal may make order that investigation into the affairs of companies required. Eligible members will be 100 members or 1 or more members holding 10% of total voting power, whichever is less. 213 of Companies Act. See, investigation can be made either by central government 210 or SFIO 212 or NCLT may order it 213. Then there are other kind of investigation like investigation into membership of company 216 and investigation into related companies, that is 219. The provisions relating to CSR provision will be applicable if net worth is 500 CR or above, turnover is 1000 CR or above, or net profit is 5 CR or above. So, the options are not given here, so that will be none of this. The compensation for loss of office, section 202 of Companies Act, cannot be paid to, that is very simple question, it cannot be paid to an ordinary director, it can be paid only to MD, whole-time director or manager. A company shall have a whole-time company secretary if its paid up capital is rupees 10 CR or above. So, options are private company, public company, paid up share capital 2 CR, it is none of this. Okay. Prior approval of dash shall be required for a merger of foreign company into a company registered under this act or vice versa. That is cross-border merger and amalgamation. 234 of Companies Act, RBI approval is required. Reserve Bank of India approval is required. Okay. Then board is entitled to appoint an alternate director in place of an original director during the absence of original director from India for a period of 3 months or more. So, from India for a period of 3 months or more. Adjudicating authority may allow the withdrawal of application admitted under section 7, 9, 10 IBC, Insolvency and Bankruptcy Code. So, this is section 12, withdrawal of application to be made with approval of dash voting share of committee of creditors, that is 90% approval of committee of creditors. The provision contained in sections dash of Companies Act shall not apply to foreign company. 77 to 87 charges applicable, 206 to 229 inspection inquiry applicable, CSR applicable. This provision which is related to share capital is not applicable. And rate of dividend proposed by board may be dash by members, that is regulation 80 of table F. It can be reduced but cannot be increased. Okay. Then if investigation is made annually by an insurer, the statement need not be appended every year. Okay. So, this is actuarial valuation and abstract section 13 of Insurance Act, but shall be appended once in every 3 years. Okay. While determining as to whether a person is resident in India or not, the period for which he has resided in India is considered, that is related to FEMA. So, preceding financial year will be considered. Mr. D, a director of D Limited, die in an accident, the board can fill such vacancy. Casual vacancy filling will be applicable if the director was appointed in general meeting. See, you have to understand, a director appointed by board, and if casual vacancy has occurred in such kind of an appointment, board cannot fill that casual vacancy. Board can fill the casual vacancy only in the cases such directors were appointed by members in general meeting. Company cannot hold an original board meeting, that is not adjourned board meeting. It can be held on any day, but adjourned board meeting cannot be held on national holiday. Which of the following measures can be taken by asset reconstruction company for the purpose of asset reconstruction? Okay. Conversion of any portion of debt into shares of borrowing company, then rescheduling of debt, settlement of dues, all of this. Okay. Section 9 of Sarfasi Act. Then if a unit has investment in plant and equipment of rupees 55 CR and turnover of rupees 300 CR, it will be, so this is MSME. So, MSME medium, the limit for medium is not exceeding 50 CR, investment in plant and machinery, and not exceeding 250 CR, this is 300 CR. So, it will be none of the above. Then decision of Cyber Appellate Tribunal, this is IT Act, can be appealed to High Court within a period of 60 days. Last question, dash is empowered to make an order for reopening of accounts under 130. Okay. So, that is reopening of accounts can be made by or ordered by court or tribunal. Okay. So, is it okay? Clear? Yes. So, we will be meeting again with another set of questions. Okay. Thank you.